It's automatically starting a transcription. Great.
Right, looks like we have a red light on, so that tells me we are recording and transcription started. So I want to thank everyone. I'll just take the lead, just open us up to get going. Today we have our law enforcement subcommittee meeting for the task force on the cannabis derived intoxicants and illegal cannabis production. And we're going to be covering a couple of different areas. And Tisha, I'm going to let you take the lead here. First, we'll take the roll call. And I'm not sure if you or Michael are going to do that. And then we'll do the meeting overview. And if you two can cover that for us and kind of tell us what we're doing not only today, but what we'll be covering that we weren't able to do today because we had been bumped by the executive branch. The governor's office got priority over us. So we're going to have that discussion in the future.
Sure, I'll take care of roll call and then we'll get started on the overview of the agenda. So Senator Przanski.
Here by video.
Rep Morgan.
Present by video for now.
Sergeant Bechtel. All right, he is running late. Rob Bovett.
Present by video.
Josh Eastman.
Present by video.
Heidi Ferguson.
Present by video.
Jake Johnstone.
Here by phone.
Thank you. Aaron Seiler.
Good morning. Here by phone.
Kurt Miller.
Present by video.
Courtney Moran.
Courtney Moran, present by video.
Sheriff Sickler.
Present by video.
Amanda Swanson. Scott Winkles. I do think I saw an out office for him.
So I see one, looks like a call in. It's 971-284. I'm not sure if that's who that is.
Okay.
It's Rosie Shafton.
Oh,
Can
hi,
you hear
Rosie.
me?
Yes.
Hi, just listening in. I'm not part of the team, but just listening in.
All right. We'll just saw a little cubicle here and just want to know who is filling that void.
Okay, so I am going to share my screen with the agenda for today. See, here we go. First thing we're going to cover is going back to the search warrant proposed concepts. There was one additional revision on there regarding medical personnel, regarding persons who can accompany the officer on executing a warrant. Then we're going to get into investigative tools. And if Sergeant Bechtel isn't here yet, we might just, Sheriff Sickler, have you and Mr. Eastman go on to criminal penalties and give him a little bit more time. But Sergeant Bechtel or Sheriff Sickler will introduce the investigative tools discussion. And then criminal penalties, whether changes can be considered that may reflect a proportionality of the criminal activity with penalty. So that's the agenda for today. For future topics, we are hoping to have a presentation from the e-crimes attorneys at the Department of Justice regarding their work and how it overlaps with a lot of the illegal cannabis operations and how that's been forming up. They recently did a presentation for the water subcommittee that was had a lot of overlap, I think, with this committee, and hopefully you'll find that informative. And there additionally is going to be a report to the subcommittee by the Criminal Justice Commission on the progress of consolidating seizure reporting with the Criminal Justice Commission and how that's going. They've been identifying gaps and redundancies in that process. and are going to have a sort of a formalized evaluation of that hopefully they can share with us in the near future.
All right, thank you. Representative Morgan.
Thank you, Senator. Do you know, are we going to discuss the wording on the recommended legislation? I had a question about that.
Are you referring to the proposed concepts we looked at before and now the third draft that went along with? Yes. Hopefully Mr. Bovet is okay with introducing that.
So
What
when
do
the
you mean
time
by
is
it?
appropriate, I have a question for you, Rob.
Absolutely, go ahead. Yeah, we talked about it last time, but I know it didn't get to folks in time to have them really kind of stew on stuff.
So a question I would have, I know that we've had to contract with local contractors with construction equipment and stuff for some of the cleanups of some of these sites. Does that have to be listed in the initial warrant, or is that just follow up and would have to be covered just like medical personnel or something like that? Is it just the first people that come on scene, or is it the whole handling of the scene from beginning to end? And you, Mr. Eastman, might be able to answer that question.
And yeah, from my perspective, it covers them all because basically that list in section 2 is just kind of an example, but it provides the common examples. But what you mentioned is what we talked about a little bit last time with Sheriff Sickler, because he'll need folks to go in and do additional stuff. But we were going to have additional conversations around that, Representative, around potential abatement processes and or forfeiture processes, kind of the post cleanup stuff. And you know, Tyler, I just see he made the mistake of popping in now. He may want to comment in on that as well. So what that laundry list would do would be to basically say these are the kind of folks that we go in with, or we may want to bring in during the processing of the search warrant. But the cleanup folks, we can certainly list them. I don't think it's necessary to, but we probably need some other remedies that we need to talk about, which I think is, it may not be today, but it may be the next subcommittee meeting. We may really want to talk about whether or not we can utilize some of the provisions in the existing forfeiture laws, the nuisance abatement laws, as well as the drug lab cleanup laws that may fit really well into covering that. So it's a long way of saying, yes, we're covered, but not done.
All right. Any follow-up to that? All right, so my understanding is if we're going to work off the agenda, we'll start with the search warrants, continuation of the discussion. This is a review of the third draft of preliminary concepts, revisions to persons who may accompany the officers, which is kind of what we started talking about, but just formally put it on the record. So Rob, I think this is yours. And so if you want to lead off with whatever else you want to put on the table for us.
Yeah, well, thanks, Senator. I'm probably going to instantly turn it over to Sheriff Sickler and Tyler as well, and Josh. So I'm here as your scrivener. I think we all recognize that we intentionally and probably for good reason downgraded a lot of drug offenses, but now we've got some pretty massive drug trafficking organization operations, and it doesn't seem like the penalty fits the crime. So I am all ears and will be taking notes, and whatever you all come to consensus around, this would be a fairly easy one to craft up. I just need to know what you all want to do. So if it's okay, Senator, I'll turn it over to Sheriff Sickler and have him dive into where he's seeing kind of where the law is not quite fitting.
Okay, before we do that, Sheriff, I just want to make sure for the record, we are under sub 2, which is still under the search warrants part. We're not getting into the investigative tools sections, or I just want to make sure we have this framed for the future listeners of this project.
Yeah, I kind of created an outline where we're kind of three of us are presenting together, which will cover the investigative piece and then the proposed penalties and some of the limitations. And I can share a little PowerPoint if that's okay. I don't know if you can give me the rights to do so, Patricia. And then that way it'll keep us on task. We'll have an outline to work from.
Sure.
No, that's great. Yeah, okay, I just want to get that on the record. So for those who may be seeing this in the future on the agenda, we're covering all three of these topic areas in the presentation.
All right, let me see what I can do here. Can y'all see that?
Not yet.
Yeah.
All right.
The share button right to the left of the leave button at the top right corner should help. And then it makes you pick a smaller square.
Yeah, I'm looking at it. There we go. I see it there. Share system. No, it's not allowing me. Hold on one second. How's that?
There we go.
All right. Okay. So we just kind of outlined this just to give everyone a little bit of background on how these things work for us. So initiating an investigation, I think it's just good to have a little bit of a reference on how these things come in. But they start with citizen complaints, and they come from all different members of our community, whether that's going to be, you know, neighbors of grows. It could be other people within the industry who are seeing somebody that may be unlicensed or suspected to be unlicensed. It can come through, you know, other governmental agencies, you know, board of commissioners. I get a lot of complaints from them as, you know, people in our valley will reach out to them as a conduit to law enforcement because they don't know what to do or they're tired of the issues. And then we get a lot of complaints from regulatory agencies such as, you know, the ODA, OLCC, Water Master, Code Enforcement in our county, and I imagine in the same, I know for sure in Josephine County and the other counties is we have a good relationship with these administrative agencies, and our staff work well together. So there's a lot of cross communication and you know, requests for assistance or reporting, and so. Another method of complaints is officers, deputies, troopers, you know, speak specifically for our deputies, but they'll show up on a call for service and come across what is believed to be an illegal grow site, or they'll get direct calls for service about a grow site. So a patrol deputy will take a call of an illegal grow and then forward that to our IMET team. All right, and then I'll turn this over to Sergeant Bechtel. I can talk about some of the investigative techniques. Go ahead.
Thank you, Sheriff. So I've kind of, if you could advance the slide there for me, I've kind of broken my portion of this up into two separate areas. The current investigative techniques, and then some that we'd like to see brought back. So again, Sheriff, I don't know if you're able to go to slide 3.
This one? This one's 3. That one?
I am only seeing slide 2.
Yeah.
Oh,
That should be the next one.
Yeah, I don't know if it's not work. Hold on, it's not moving. I can.
We're on 4 now.
So you guys can see it now?
Yeah,
Yeah,
we went
but
1 too far forward.
All right, is that better?
There we go.
Okay.
Our investigative techniques. You know, one of the first things that we're doing when we find out about these, especially in large rural areas. Speaking of large rural areas and large grows, my apologies for being late. I came down to a place where I could get Wi-Fi from search warrant service that's been going since 6 a.m. and is still going as far as the clearing is concerned. So massive size of these things. A small county has taken an entire morning and everyone they could get a hold of to take care of it. So aerial surveillance is a key component. Right now, we have drones up over the search warrant that we're serving. They're absolutely integral to our mission, but we need a warrant for those. We do have access. A lot of counties have planes. We can use the Oregon National Guard counter drug program, but we're seeing a lot of challenges to some of the advanced cameras they have on them. So that's a hurdle for us sometimes. Informant-based intelligence, we love that. You always have to question the motive to help. Oftentimes our informants are from the industry, which is great. OLCC licensees will come across some nefarious activity, and of course, they always want to help that unlawful competition. Other informants might be working off charges. And then we always have an ex that is willing to inform, an ex-business partner, an ex-domestic partner, or the competition. The other thing that we go for is knock and talks. No trespassing signs will stop this dead in our tracks. So in the large outdoor rural grows, we can't pass that closed gate. We can't pass that no trespassing sign. And then there's ground surveillance, sitting out in a car, crawling through the woods. But that's super, super hard when you get out into those rural areas. And might I say dangerous. You need 3-4 cars to effectively follow safely. That was illustrated to us recently in the Northwest here when Sergeant Jeremy Brown in Vancouver was killed while on undercover surveillance. If we could move to slide 4.
Did it move?
Yeah, it did. It did.
Okay.
So, some of the other things that we've done is we've done pretext stops. Those are increasingly hard with current case law. We're only allowed to question for the violations. So we at least have to have a reasonable suspicion when we're questioning someone beyond the traffic violation. Of course, we lost the time-honored tradition of digging through people's trash in a trash bowl due to case law. So that's not an option to build us up to probable cause. Some of the other things that we need probable cause for that we used to have were car trackers, body wires, and phone pings. Now, those were all available to marijuana cases prior to Senate Bill 302 in 2017 when marijuana was removed from the State Controlled Substances Act. The statutes are still there for certain crimes. For instance, it might amaze you to find out that if you're transporting metal without a metal transfer certificate, a Class C misdemeanor, I can absolutely track your car. If you are breaking any one of our wildlife laws, all wildlife laws in Oregon are unclassified crimes, we can track your car. Commercial commercial fishing laws, we can track cars for that. And we can track cars if you're a fishing guide operating without a fishing guide license. However, we lost the ability to do that for marijuana crimes. Really important when you think that you can't really surveil them in a rural area, and up north, especially when we're dealing with organizations that are running 15, 20 different grows, getting all of their residential indoor grows, trackers would be really helpful in that. Body wires. This was something new to me that we actually came across recently when we wanted to send someone in with a body wire, an informant, that I couldn't do it anymore. Same situation as marijuana came out of Senate Bill 302, or the Controlled Substances Act in Senate Bill 302. We lost that. And then we've got phone pings. Phone pings, we do have a little bit of a workaround on these larger cases where we can show a pattern of racketeering activity, that this isn't just an isolated crime. We can ping a phone or use geolocation on a phone. And when I say real-time geolocation, keep in mind this casts a wide net, anywhere from 50 meters to 2,500 meters. But that still gives us an idea, and we can kind of triangulate off of phone towers where a person's going and where a person's been. So that phone ping, we can still use that in some cases. We just have to articulate a pattern of racketeering activity. Again, all available to us before Senate Bill 302 and the removal of marijuana from the State Controlled Substances Act. If I could have you advance the slides, Sheriff. So I guess what I would be proposing, and we've had a couple emails back and forth, is a fix that at a minimum was in Senate Bill 1561 in 2020 before there was a walkout, and it died, I believe, in a Ways and Means Committee. It fixed car trackers, it fixed phone pings, but it didn't address the body wires. Honestly, I don't think anyone noticed it was gone. There's the text. It's a simple fix, just adding those predicate crimes into the statutes that I referenced, in the slide prior. Of course, it has 475B there, and I know they're probably all 475C now, but that's three real quick fixes that law enforcement would love to see. That's it for me.
All right, thank you, Sergeant. We'll move on. And now we have DA Eastman talking about sentencing in Oregon and how it works, and why we think there's some changes that need to be made with regards to these large scale operations.
So I didn't send my copy of the criminal history grid that we all use. That's Lane County graciously laminates and updates every 2 years. But it says on the bottom, do not reproduce. And so even though this is official use, I don't use it. I didn't send a picture of it, but most probably know, if not all felonies that aren't statutory sentences are alphanumerically scored. And there's a line for probation and a line for Department of Corrections. For the cannabis offenses specifically, and controlled substances as well, I kind of categorize them as 1, 4s, or 8s. The methamphetamine, heroin, fentanyl have 9 and 10s potentially, but typically it's 1, 4, or 8. So possession, if it's a felony, so 8 pounds or more of usable marijuana, is a 1. So it's 10 days and probation. Manufacture or delivery, which we don't ever charge delivery anymore based off Hubble. So manufacturing is 4, so no record is 20 days, and the maximum is 11 months in the county, which, as most jail, I know Sheriff Sickler has a similar jail issue that we do. We try not to put anybody in county like that. So those are the most common. 8 is available if it's a commercial drug offense, or a CDO for meth, heroin, fentanyl. Typically now it's all for fentanyl or meth. There's 11 factors, 3 or more of which have to be proven and alleged. And they're think of stolen property, $300 or more, packaging materials, public lands, firearms if it's unlawful to have them. Kind of what you would think of, basically a list of things when you think of drug dealer or this is a business, the things associated with that. Those also all include weights for meth, heroin, fentanyl, and those make it an 8. So then the presumptive sentence there ranges from 16 months to 45 months, but typically the GHIs are still probation, and sorry, the letter is based on your criminal history, but so little criminal history and you have a pound of meth, $300 in a gun, it's potentially still probation. Let's see. So marijuana is a little different, and I had mentioned this, I think, the first meeting, that if it's not a commercial marijuana offense and it's an 8, it's a 4 regardless of how much it is, because unlike meth, which is there's 10 grams makes it more serious, 100 grams makes it more serious, and then 500 grams or more makes it elevates the consequences. Marijuana with legalization and the 302, we've kind of gotten rid of the weights. So absent those other factors, money, guns, packaging materials, public lands, 13 plants, which would be a felony, more than 12, is the same as 200,000 plants. So we've had them where there's a multitude of greenhouses and nothing else on scene, and that person's maximum sentence is 20 days and 2 years supervised probation. Whereas somebody who has a right to have 4, but they grow 17, that's the same sentence as the law currently is. I think in 3000 we got cultivation for marijuana or the plants, and now we don't see that anymore. That sort of playing cat and mouse with the illegal growers. Hemp doesn't seem to be anywhere anymore, so we don't see those. As I mentioned, the distribution of marijuana follows the same grid as manufacturing, but with State v. Hubble making possession with intent to deliver an attempted delivery, it's actually less serious now to possess with intent to deliver than it is to possess if it's a commercial offense. So we just don't charge it. It's harder to prove and it's less serious. So we don't have those. Almost every case we have now would be an 8 in Josephine County based on, we get there because there's always money, and they are creating or modifying structures. So almost every one of them now has hoop houses, which are modified structures. And typically there's one next door to that has, it's sort of a start/drying that has changed the lighting, material, etc. But most of them are 8s, but it's still probation most of the time. So, and it's not we're seeing them the same individuals each year because that's it, penalty wise. I think that's it unless there's questions about that part.
Are there recommended, oh, I'm sorry.
Go, Lily, go ahead.
Thank you, sir. Are you guys making recommendations of any changes? I know that we had heard from the other committee or other subcommittee that they were interested in seeing a tiered approach, or I see this proposed changes here, but as far as what would define penalties for larger site, what tier, I guess? When does it reach the next tier, I guess?
Yeah, that's a good question. I think that certainly would be a good discussion. I mean, I think when you're talking about some of these DTOs, there's certainly a tier there. And then and Sergeant Bechtel he's on the ground much more than I. But I think there's probably an in-between level as well. When you get to individuals who are clearly growing marijuana for profit, illegally for profit, versus, somebody who has 13 plants or whatever, 14 plants. These are all different categories, in my opinion. Do you guys have any thoughts? Sergeant Bechtel?
Someone, let's see.
Maybe
Tyler,
he dropped off.
He's on mute right now.
Oh. Anyways, yeah, I mean, I don't know where the level should be, but there is.
My apologies. I took a phone call.
No
What was the question?
We're talking about the different tiers of where maybe, like what level triggers the next tier of, say different penalties if we were to move into something like that. For instance, we have the standard if you grow more than 13 plants or 13 or more, and then what level next up, is reasonable. And then of course we're talking about the DTOs and what do those look like and things at what level.
Yeah, sure. I mean, one option would be to mirror the federal law, which is 100 plants, 1,000 plants, 10,000 plants. I'd certainly like to see enhanced penalties for exploitation of workers. You know, allowing people to camp in hazardous conditions. But I mean, I can't tell you, we've had significant operations in a house that only have you know, 100 to 150 plants, but their value is so much higher than an outdoor grow, because they can be grown in a controlled environment. It's a higher quality bud. So the number of plants, it's hard. And then you get into you know, you get a clone with roots on a root structure on it. Well, technically it would be a plant. If you look at some medical laws, it wouldn't be considered a plant until over a certain height, but then that gets really convoluted really quick too. But as it stands now, per statute, a clone, where, you know, on a typical conference room table like I'm sitting at, you could have 5,000 of them. It becomes dangerous to do it by a number of plants. I hesitate when we start talking about size, because you know, we used to go through challenges on height quite a bit, and I've seen them grow a plant this tall but that wide. So I talked a long time to not give you an answer.
And those are all good points. It is difficult to say, you know, what goes to the next level, but the one thing that isn't working is a deterrent currently, where somebody can put up 150 hoop houses or 100 hoop houses and really face potentially the same consequence as somebody who has 2 hoop houses. And how do we deter that kind of activity better than we are currently doing?
Yeah. Someone has their hand up. I can't tell who it is. I'm going to see if I can figure this out.
It's Courtney Moran.
Yes.
Okay,
Hi.
Courtney.
Yeah, so I think Sheriff Zickler and Tyler just really hit on what I wanted to bring up, is that the current penalties, right, they're not deterring folks. And I think overall, since marijuana has been illegal even under federal law the last 50 years, the illegality itself is not what's deterring people, right? If folks want to grow this crop, they're growing it for monetary profit, and they're going to go after it regardless of the legal status. So what some criminal defense attorneys have recommended to me is that, what if we set up more of a fine, right? A penalty based on the number of plants, that's a fine, not just, you know, this level of felony or what have you, but actually creating like a fee structure, a fine structure, because it's the value, as Tyler mentioned. And if folks are going to have a monetary penalty, I think that's going to be more something that will hit home more and be more of a deterrent than just a crime itself.
That becomes difficult because of ownership. You know, often the people that are charged are just workers, and there is no ability to pay fines. So that's something to think about. And sorry, I didn't raise my hand.
That's all right. No problem. We're having kind of open discussion here. Lily, your hand's up.
Yes, sir. Well, just a real life story. I have a local farm. They're an organic farm who does both animals and other agricultural crops. They have the oldest water right in their district, and I went out to the site and they said, there's the Israelis, Bulgarians, Russians, Mexican controlled grows surrounding us. They had to sell a significant portion, over about a third of their animals, because they couldn't grow the feed to feed them because the water diversions. And it's been reported over and over to different law enforcement, but the family's response was, we can't fight having our water diverted and being met with armed guards every time. So we just sold our agricultural animals, you know, that were our bread and butter. So when I see the proposed changes here as far as enhanced for water use, I don't know if this is going to the other, the Natural Resources Subcommittee, but I have people in my district that feel there is no legitimate, if it's not a legal crop, if they're growing for profits outside of the law, then the water use should be criminalized as well. And that even if they had a water right, it should be criminalized if they're not getting the penalties. And I don't know if that crosses the line with our committee versus the Natural Resources Committee, but when I see water use, that is a huge concern in my district, and especially with drought conditions and everything else going on. And when we got farms that are having to sell off there and not be able to operate legally because of what's going on, that is a concern too.
Josh?
I'm on the phone. This is Jake, so I can't raise my hand. I apologize for interrupting there.
Sure, go Jake.
Yeah, I just wanted to mention, and I think it bears repeating that the Water Resource Department, there's 54990. There already is criminal statute on the book, and there are groups, I think Mr. Easton and others, who are already looking at criminal as a part of the process. It's just not a very effective tip of the spear. We don't have a big history of utilizing criminal processes. To my knowledge, the department sought it on its own maybe twice in the last few decades. So that is something we're working with the the ECRU, the Environmental Crimes Unit, as well as local district attorneys' offices to see if we can be more effective in utilizing that criminal deterrent. I think the other thing, though, that I want to just take this second to point out, though, the difficulty with the fine structure is that and Sergeant Bechtel pointed it out accurately, whom are we going to go after for an administrative penalty? Fining, some field worker or some non-existent responsibility party is the biggest challenge that we face utilizing what is our usual process in administrative. I apologize, I don't have a great answer here or solution. I just wanted to point out those kind of points. Sorry for interrupting. Thanks.
Thank you for the input. Josh, go ahead.
So I want to kind of address a bunch all at once. So to Ms. Moran's suggestion of fines, we often avoid that in the heightened penalties in the criminal, at least here, when, say, somebody with means offers to, instead of going to jail, offers to pay more of a fine. We sort of push back against that because that sort of gives people's preferential treatment who have means as opposed to those who don't, who commit the same crimes. Sergeant Bechtel said a couple things. He said we charged the workers. Down here, we never charged the workers. We charge who's in charge, or at least who we can determine who's in charge of the grow. And with the 5,000 clones on a table, a simple phrase after the number of plants that says something to the effect of are on their way to maturity or a part of the operation beyond starts. I don't know the phraseology for that, but that would alleviate that to where, because what we're talking about is that plants in the ground, 13 is currently the same as the one I went to last year, that 250,000 plants, and those aren't the same thing. There's other things we like, the next ones on the list, environmental degradation, water use, those all address kind of the same thing, but just the plant, I get it's a difficult one, but I think if you could allege something to narrow it to plants that are on their way to budding or whatever, something, I don't know the right terms, but so. I think that's it.
All right. Looking for any other input?
I don't know if there's any reasonableness to just a number of, like, say, hoop houses or structures as a guideline. And those seem to be the pretty egregious ones when you have these, 100 hoop houses up. They're massive and they use a lot of resources. The sergeant mentioned how long they had been out this morning just trying to begin their, the dismantling piece. And we have to send our staff out, and it's a very resource intensive operation with a lot of moving parts and factors. And it really does take a lot of effort to take care of these grows. So I don't know if there's something to be done there with just the sheer size of the property. I don't know what the number would be, but those seem to be the real challenge. Up 3 or 4 hoop houses. Yes, it's illegal, but it's not we've got to call 150 law enforcement agents from all over the state to come serve it like they did in Joe County last year, or 200.
So let me jump in, and then Josh next, and then Lily after that. So I guess there's a couple things I'm taking away from this, and Sergeant Stickler, I see and I agree with what I've seen visually when you have these multiple hoop houses that are on the properties. Now, I'm assuming from everything, the technique and technology is that people who are doing this are going to hoop house models as compared to just open grow, so they can control, regulate the grow and get a turnaround and multiple plantings or whatever you want to call it, cycles. And it does seem to me that we should be able, and I don't know if I would say the number of hoop houses as much as maybe just the area that's covered that include hoop houses would be something that we may want to look at, because that gets you that high volume. And then I thought it was interesting to hear also on the indoor grows, understanding again, you have much more control over what's being grown and how it's grown, and getting probably more efficiency out of that growth cycle. And that in itself seems like it would be another reason for enhancement as compared to someone that's dabbling in this, or a mom and pop type of thing. They're it's not right, and they should be held accountable if they're mixing I want to call it THC cannabis in with hemp. But at the same time, if you're talking a handful of plants compared to running a whole show here that's really all THC with just a little bit of hemp, that seems to me should be those type of aggravating factors that the court should be taking in consideration. So let's go with Josh, and then Representative Morgan, and then Sergeant Bechtel.
Senator, can I
Yeah.
interrupt real quick? I have
Sure.
to hit the road for another meeting, so I'm going to have to leave here just momentarily.
Yeah. Go ahead.
Quick question. I'd love the feedback from yourself, Senator, and the others. I know federally we have RICO statutes, and where it's clearly organized crime. And I'm wondering, does Oregon have an equivalency and is it something that needs to be looked at? Is it meeting the needs of what we're looking at with these drug trafficking organizations? Because essentially that's a level of what we have on some of them. And is that a statute that is suffice, or do we need to look at that to enhance? When you have 250,000 plants, that many workers, that many places at that level of organized crime, what's the appropriate level to hit that? And is that penalty enough to enhance it?
So let me jump in and say, I think our gurus here, certified smart people, is Josh and Rob. So I'll go with Rob. Josh, I just wanted to give you a heads up that we'll put Mr. Bovet in the hot seat, knowing that he has dealt with this issue a lot.
So the answer is yes, Representative. We do have a state RICO statute that kind of mirrors the federal statute, but it's like the federal statute. It really does focus in on predicate acts, so it's a higher burden to kind of prove out. And I don't know that it's used very often, but I'll defer to Josh for further commentary. I think we could enhance that as well, but it might be just as easy to directly go after the enhancements that Josh, Tyler, and the sheriff have talked about, but I'll defer to Josh.
So, Rep. Morgan, RICO, there's a state counterpart. We done it once here. I did it with RAID, and you have to exhaust all less intrusive means before you even try to go to the wire, Title III, etc. And then so the RAID guys, with help from every other agency around here, were working 80 to 100 hours a week during that. I mean, it's about double what normal, in order to monitor and all of the restrictions that go through that. And that was a local Oregon isolated prison gang. So in order to do it in these basically transnational DTOs that we have now, our judges can't authorize them to, I guess they could listen here, so anything outside of here, but we're confined to where our judges can authorize us to go. And resource-wise, I have suggested this to the teams locally, but it's, yeah, at least there's not enough resources for us to do it based on what my experience of how much it takes just to do an wholly in Oregon one with 5 defendants. So.
And if there is a legislative fix that would help with that, I guess is what I'm asking. Or is it just what it is?
My response is that that's sort of what the federal government is for, and we reach out to them and we started and try to have them take it. It's just been different with cannabis as of late, but legislatively, I don't know how to, because there's so much interplay with constitutional and it makes sense. All the hurdles you have to get to down the racketeering road are because of the increased government intrusion into privacy. At least that's what mine was. So.
All right, I think we're back on the board. Sergeant Bechtel.
Thank you, Chair Brzezinski. I wanted to speak to the indoor grows, and I can kind of relate it back to that current racketeering conversation. Just to kind of give the committee an overview of what we're looking at. We're looking at ethnic-based organized crime operating anywhere between 5 and the most we found is 25 locations at the same time indoors. And so, you know, we want that racketeering pattern and that racketeering case going back to Measure 91. I mean, the whole idea is to keep organized crime out of Oregon. And we just haven't found a prosecutor that's willing to take it. And a lot of that is because of the new model of being organized crime. We think of a pyramid with, you know, El Chapo or the Don at the top, but it's better to think of these as spider webs or sunbursts, and there'll be certain levels. There'll be workers, there'll be managers, there'll be brokers, there'll be managers that might you know, be like a lieutenant, a regional manager, but the owners might own 1/3 of this grow and half of the other grow. And so it gets really intertwined really quickly. Throw on top of that this is a transnational and ethnic-based organization. There's really no way to get at them through a state wiretap that we would have the resources for. So it's extremely resource intensive. I've been involved in a state racketeering case that ended up with phone taps. It took us about 7 or 8 months on one case, and I could easily see spending, you know, 5,000 man hours on that, like we have on our past organized crime cases. So I don't know what the answer is. I just wanted to kind of give the perspective of the indoor grows that you're seeing. Primarily in the north half of the state, but I've seen them start to trend to the south. And so I think I'll leave it with whatever we come up with as an enhancement based on number of plants outdoor. Just realize we have to have something kind of commiserate for these indoor operations. Otherwise, all you're going to do is push people indoors, where now you're looking at a year-round problem down south. We're talking people, one house using I've seen up to 40 times the electricity as the average household. So.
Yeah, another thing that would be interesting too would be for repeat offenders, if there could be tiered as well. And I don't know how that looks. Maybe Mr. Eastman can talk about that, but we do have instances where individuals will pack up and move to another site. They open up, they get a different LLC, and they just really kind of skirt the systems. And there's not a lot that's easily done with those either.
Yeah, I think that's something that we could easily move into. I think I want to go back to what Tyler said about the indoor. My concern, which I think many people here would be, just the abundancy of these means more safety risks, more issues because of how people are, I'm going to call it hot wiring their houses to get the electricity there, which means more chance of fire, etc. And if they're doing this in residential areas, now we're putting, a lot of people and their properties at even more risk than, I will say in an open field area. Not that it's right for either one.
Chair, if
go
I
ahead.
could interrupt you, we are going to about one fire a month. That's the result of a marijuana grow, and I have a real fear that it's they pick rural properties for these indoor grows too, because they don't want to have neighbors real close to them. I have a real fear that with fire response times, that we're going to end up with a forest fire at some point.
Yeah, and to me, I think we can actually have those as enhancements as well as to what the sanction and penalties could be. I also think that under our state RICO, and Josh and Rob, please correct me because I don't do this type of work, but it seems to me that those could be predicates for repeaters in the sense of if they've been engaged in this operation, as Sheriff Stickler says, in one location, they pick up, move over, start a new LLC, that we could actually still be able to, hold them more accountable. Because, that's just like the price of doing business, moving from one side to the next. And, we're not really stopping that activity. We're just moving it to another location. All right, any comments? All right, so, we on our agenda, we had these kind of breakouts, but we've kind of consolidated and put them all in. Let me ask for, on the presentation side, is there other material you wanted to put on the table for the group to be discussing at this point? Josh, go ahead.
So I had in the email between Sergeant, Sheriff, and I had one that had come up for me several times recently where I have rejected a landowner referral because when it's an aid and abet to an offense, so when the landowner's leasing it, structuring or layering by getting a lease and an LLC and all this, and then I can't prove when it's a year later that they with intent to promote a cannabis grow, because it's a higher burden when the theory is aid and abet. So I had thought about, man, if only there were like a reckless or a negligent, a knew or should have known, that was less severe of a penalty, but at least that way could address the landowners escaping. Basically, down here they take huge cash sums and then, oh, I thought it was hemp, or oh, I didn't know, or they told me it was only gonna be hemp, and then I can't get around, we can't prove that or hold it or deter that. So
John, I know we're on tape. I'm just going to say, unfortunately, I think that's kind of a BS as to their mentality or their intent, their knowledge. So, if someone's giving me $50,000 for cash to lease my land for a year, I should be on notice, as to what the hell are they going, what are they doing there, and what are they growing there? And maybe there needs to be some other requirements that if someone is going in to do this, maybe they have to provide to the owner of the land that they are licensed under OLCC, or they're licensed under, whoever, for production of whatever it is. There seems to me ways that we can do it. And if not, or even if we do that, your point's well taken. I think easily we could set up different degrees of aid and abet and have your min raise for the, well, I should have known as a third, let's just say as a third degree aid and abet. Second degree would be something a little bit higher, and then your normal would be now a first degree. with the intent knowing that you could actually prove it. So, Rob, help me on this as to, it seems to me we should be able to put that into the works.
I think we can. I guess I was going to say, as we get a little closer, I think I'm hearing maybe a consensus around cleaning up the statutes that we almost cleaned up in 2020, plus adding the body wires. Those are easy to craft. Would you like me to have a shot at crafting something around this specific issue as well? But I'll say with a caveat, you're all going to hate it. My first draft, you're all going to hate, and that's fine. And then you can tell me what I got wrong, but at least I can put some words onto paper you can have a look at.
Please, yes, and we'd love to hate the first draft.
Yes.
So I'm not sure, Tyler or Sheriff, which one of you came up on the board first?
Tyler.
Thank you, Sheriff. I can defer to you. Yeah, right.
Well, I was just going to mention, maybe pose a question, or maybe a rhetorical, but if we were able to charge somebody for this negligence, or, you know, being oblivious, so to speak, to what's going on their property, would that aid in any seizures of the funding they received? Would that help that process differently? I think it would. And again, a kind of a rhetorical question for the group, but I think that is important, because we have had many instances where we've talked to people and they literally spent more time, you know, vetting the color of their house paint than who's growing what on their land. And that's true. And so I do think that there is some room for this type of statute, and then we can go after the profits that they made from this deal, which will probably make it less appealing for people to want to try to even engage, even if it's a low-level misdemeanor. Losing that funding source would be probably the true teeth in this.
Yeah.
And that's all I had, other than, I don't know if it's still on the table to discuss, since we're talking about drafting, is the being able to destroy the hoop houses with articulation in the search warrants. I don't know if we had any more progress on that or thought.
Could I add one more to the last topic before we go to that one?
Yeah, go ahead.
Not only on the property owner should have known, reasonable expectation of knowing, I was asked to consider that they lose their ag credit in their taxes if they grow to an illegal grow. And that's another penalty that might be worth looking at, is you get a property tax break if you're a farm, but if you're growing illegally, do you still get that tax credit?
Yeah. Let me just say, I think that is maybe going into a second offender or third offender type of approach. I don't know what the Farm Bureau or others might be thinking about how that would be written in such a way that it's not, let's say, too zealous in the very first time. I mean, I'm not saying there wouldn't be a situation where it could be appropriate. Rob, I don't, Tyler, you're up on the screen, but I'm going to let Rob go because I saw a facial emotion that I kind of was trying to hide. So go ahead.
It's just, I hear exactly what the representative is saying. I think it's actually a good idea, but the hoops we'd have to jump through to clear the opposition away would be pretty profound. I'd have to talk to the assessors, talk to the tax collectors, talk to the Farm Bureau. You can imagine all of the various interests that would want to weigh in on every word of that one. I think it's worth still talking about, but maybe we can think about that one some more, because before I craft that or anything that looks like that, I'd want to have a lot more conversation around it. Right now, I've got on my punch list, this is to let you know, Chair Przonski, if it sounds good, the Senate Bill 1561 fixes that were covered earlier. We've got the tiered approach. I think I can do something that mirrors what's happening federally. Got the aid and abet fix. That'll be a little more detailed. And like I say, you're going to hate the first draft. And then destruction of hoop houses I can deal with. So I can craft those 4 items, but I guess I prefer to defer any property tax issue to some later time, because that gets really complicated.
Yeah. Thank you. I agree with that. Tyler, why don't you go ahead?
Sure. With the aiding and abetting, I just wanted to bring up that what we're dealing with is a plausible deniability 3 times removed. So as a property owner, you're going to lease it to somebody who's going to sublet. And then, in our cases, we don't even really know the true property owner because the person that's on paper is a nominee. So
Are you the only one based on to this meeting?
So they're actually often not even in the country, not even in the state. So they would have no direct knowledge of what was happening in their property. So that becomes really difficult. We deal with the kind of aiding and abetting from a different perspective because we have the same ethnic-based electricians, HVAC people that we end up contacting again and again. It grows, and their plausible deniability is, I just install AC, I just install electric. Yeah, they should know that when you put 20 AC units in a horse barn, that it's probably not for horses, or they should know that when they're putting in a 600 amp service with no permits, that they're aiding and abetting, but they stand back. They're hired again, three layers of plausible deniability away from the person who really controls that. So it becomes really hard, again, to identify who that aiding and abetting goes to. I think it's a little more simple in a traditional cartel comes in, your land is worth $150 an acre for the growing season. You're getting paid $1,000 an acre. You should know better. That we could definitely craft something for that because it's simple, but I just want to let you know that that's not at all what we deal with. We deal with cases that we really will never know who controlled it or who owned it.
And that's part of why you're not going to like my first draft, because it's not going to be as comprehensive as you want it to be, because I don't think I can craft that.
One more thing, just before I turn over the mic. We've resorted to what we call an education. We modeled this after some problems that Multnomah County was having with UUMVs. So the first time they catch someone in a stolen motor vehicle, they present them with an education that tells them all the different things that stolen vehicles have. You got it from a guy you only know their first name. It uses a screwdriver and an ignition to start it. They list all of these things out. Well, we've resorted to serving the electricians or the HVAC people that we come into contact with this education about things that, they pay over market. They only pay in cash. You only know their first name. We have this list of things that we give to them, and that gives us something to go after them for the second time around.
Not sure what happened to Chair Przanski, but it looks like Rob, you're up next.
Yeah, it looks like we lost the chair, but I was going to say we do something very similar with civil forfeiture.
Sorry, you didn't lose me. I had to shut the window. My neighbor decided to put on the lawnmower, and it was as soon as I turned the mic on, I knew you were going to hear a bunch of static. So.
Yeah, and so Tyler's spot on. We have that same situation in civil forfeiture and have had since '89, where essentially sometimes we can't actually prove that the owner or possessor of the property actually knew it was being used for the unlawful purposes. And so the way you divest a person of that is you give a notice. So it's very common for forfeiture counsel to give a notice to people who have that innocent claim. You essentially strip their innocence away from them the next time around. And so what I'll probably wind up building into the draft is something to that effect, which will seem unsatisfactory to some, but I think that's just the practical reality that Tyler described.
So I'm going to go back to let's say the subcontractor types, such as the people doing electrical work. I mean, if someone says, I want you to put in a 600 amp board here, I mean, doesn't that require some type of a permit? And if they're not getting the permit from the county, I mean, that in itself should say, that they're right in the middle of it.
I think that was directed at me, Chair. So what we're seeing is they'll permit up to that panel. They'll, you know, have a fictitious use for it that they'll give the power company and the county. Once that panel is permitted, then everything on the other side of the wall is fair game.
Oh,
And yes, it does need a permit, and yes, it does need
Yeah.
inspection, but that's probably the least of their concern.
so dealing with that, so basically that would take you back to, let's say, the county permitting, whoever's going in and getting the submits the application for the permit, as compared to the contractor doing it. I thought most of the time the contractors would be doing that.
Yeah, you would think, but there's people that are hired to simply manage the properties. And
Okay.
when we're dealing with transnational organizations or ethnic-based organizations, they're usually, oh, I know nothing about what they're doing, but I speak English, so I'm the one that arranges the permits. And so that's what we're getting. Even though they arrange the permits for 20 places and 20 places only that we could find, and they all happened to be unlawful grows, that is, again, and they honestly will never be there after the illegal activity starts. They will be there through the permitting process and getting it set up. They step away, and then the unlawful activity starts.
So why
And
would
so they are just a
counties and-
contractor.
Yeah,
Sorry.
yeah. So why wouldn't the counties themselves, in the sense of the building permitting, be, let's say, on notice? The same guys coming in here and getting multiple permits for multiple locations. That seems to me that, you know, they're probably on a first name basis pretty damn quick after they come in there a few times.
Yeah, and they're Facebook friends, and sometimes envelopes are
Got it.
passed.
Yeah, I got it.
But they're also they're turning that information by and large over to us very, very quickly and very easily, and that probably has a lot to do with my 200 to 300 ethnic grows that I've got backlogged.
Wow. All right. Other not concerns, other discussion on the topics we have. Rob, I know you've been doing your punch list, and thank you very much for going over it. I'm going to ask you to just go over it one more time so everyone can hear, to see if it captured everything everyone else was hearing and maybe wanting us to consider.
You bet, Chair Przonski. So at this point in time, I think what I'll do is I'll create a new fresh draft for the 4 issues that I think I've identified. We've talked about here today and previously, but the 4 that I'd be crafting would be essentially the equivalent of Senate Bill 1561 in 2020 that dealt with 2 of the statutes that Tyler meant. I'll add the 3rd one, body wires, and deal with it in the same fashion. The second area is I'll just come up with a rough draft of a tiered approach to penalties for possession, similar to what was described before. You may not like those, but at least it'll be a starting point to look at. And then 3rd will be the aid and abet thing we've been talking about a lot here. I'm going to have to really put on my thinking cap and come up with something. And again, the caveat is you're going to hate the first draft, and that's fine. And then 4th and finally is destruction of hoop houses and creating the process and procedure for that to occur.
All right. Tyler, your hand's been up. I'm assuming it's up from previously. So we've heard the list that Rob's going to be working on in addition to what he's already put together. Is there other areas that were discussed today or something that we want to discuss since we have some time here? Josh, you looks puzzled there, so.
Yeah, so I had thought we were, it was mentioned about inhumane worker conditions or something similar to that. And I had thought about just the state further alleges the above described offense involved inhumane work conditions, or environmental degradation, or some combination thereof, to sort of general terms that would encapsulate kind of all of the different worker issues we're seeing, as well as the pesticides and other nasty things that are. But I didn't hear those on the list, so I just thought maybe those.
That was, Josh, that was just me being shorthanded because it's under that same block of stuff where I've got the tiered approach. So I was going to plug in the enhancements to cover those issues that you mentioned and treat them just like enhancements, if that's okay.
Tyler, you're up.
Yeah, a quick question for the group. Does BOLI have a list of minimum living standards? Is it rather than trying to rewrite it, is it already written somewhere out there in state law through the Department of Agriculture or BOLI?
Good question. I don't know the answer to that. I would assume there's got to be something that they use for monitoring when they go in and see these camps, that they're doing some type of they got some type of standard list they work off. I'm going to ask Tisha. Go ahead, Aaron.
This is Aaron Seiler from BOLI. I will only say that we're primarily looking at wage and hour issues when we go in. I would believe OSHA might be the appropriate conversation to have in terms of basic work conditions for worker safety.
Correct.
So Tisha and Michael, if you'll work with Rob, I know Rob's going to be doing the drafting, but if you give him whatever assistance he needs to get that information or find out which agency or agencies would have oversight, that'd be great. Sheriff?
Yeah, just a quick concern with that. I'm all for that. I don't know if there's something to craft in there though that allows officer observations to be considered in that, instead of having to bring individuals to court to talk about the inhumane conditions. Just because I don't know what the likelihood is of us being able to get these individuals into court a year later. Anyways, I don't know if there's some possibility there about, documented, of course, and saying what a reasonable person would consider instead of having to bring.
Yeah, I think that's going to be the standard that would be in court. I'm not looking for did they meet the checklist of whatever these agencies may have. I think what your officers or the deputies are doing is to what they are putting in their reports, and then they're coming in and testifying. And Rob and Josh, y'all help me again on this. It just seems to me you put the facts out there, you make your arguments, and then the jury's going to decide whether or not it did or didn't meet those enhancers.
And that would be correct, but I hear the sheriff's concern in the sense that it really depends on how it's crafted, and that's why I'm going to be cognizant of that. If we need victim testimony to prove an enhancement, the sheriff's point is we're likely not going to have the victim to be able to testify. So we need to craft it thinking really it's the documentation of the circumstance, not what was in the victim's head, but the circumstance that the victim was being exposed to.
Yeah,
correct.
Good catch. All right, what else in this area? Well, the way we're going here, we may actually have lunch at noon.
Chair, so just to make sure we've gone through everything on the agenda, there was also the task to go through that third draft of Rob's preliminary concept regarding persons who may accompany law enforcement on execution of a warrant. I don't know if you still want to do that.
I do, if we have, if people had a chance to go through that draft, I know, Rob, you're going to be working on another draft that probably would incorporate that in there. But if anyone has looked at that draft and have comments or concerns, this would be a great time. So Rob would have that while he's doing his next draft.
Chair Brzezinski, I have looked at it and I have no comments or concerns, and I am going to bow out and go chop some plants until dark.
Okay. Well, have fun. Thank you very much for your service. And thank you
Thank you.
very, very much for being here today with everything else you're dealing with today.
Appreciate it. Thank you, guys.
Thanks,
bet.
Sergeant. Be safe.
All right, so any other individuals wanting to put anything on the table regarding that third draft? Not seeing or hearing anyone. I'm going to go say going once, going twice on that. All right, and Tisha, I know that you're there. I know we don't have a meeting time set yet, do we, for our next meeting?
No, we don't. We want to make sure that we can get law enforcement when they're not too busy with current operations as is happening right now. So we'll figure that out and hopefully get something, if everyone's available in September, get a September date circulated for you.
We'll do our best to work with all the players to try to accommodate the best we can. I do think that we should try to do that. I'm just going to say, Rob, you tell me if I'm wrong on this. I just think we need to probably do it before the ledge days, so we can have because the day for getting bill drafts filed is the Friday of ledge days, and I don't have the date in front of me, but it's like the third week of September, if I'm not mistaken. I think it's
September
like
23rd.
Okay, so the 23rd. Now, what we will do, if necessary, we will put a placeholder or two in. Placeholder, for those who aren't familiar, would be just skeleton bills with a relating clause that would be broad enough to bring subject matter in after the deadline. So we kind of reserve a slot with a bill, and then we can come in and we can fill in the text for it. Then it gets vetted through that process, but we don't actually have to have every word, every T crossed and every I dotted on the 23rd. We just need to have the concepts in place.
And Chair Przonski, my calendar actually freed up pretty heavily this week and next week. So I anticipate having a draft for you to at least look at by the end of the week, if not by tomorrow or the next day, at least these 4 latest items, so we can play around with drafts.
Okay, great, great. What else for the good of the order? All right. Well, if not, I want to thank everyone and Representative Morgan. I hope it looks like you're still on, so I hope your meetings in Medford go well. And for everyone else, hope your day goes well too, and be safe out there. Take care.
Thank you. Have a good day.
Yeah. Bye-bye.